And welcome back to the program. It's the Vicki McKenna Show. Standing by is Luke Berg, who's deputy counsel for the Wisconsin Institute for Law and Liberty. And I'm just going to confess here, I guess I'd forgotten about these two cases, Luke, that are making it harder to unpack the whole, alphabet mafia, transgender cabal craziness in Wisconsin schools. In a select series covered by the Seventh Circuit, I'd forgotten about Whitaker. I'd forgotten about this other case. What do these two cases mean? And then we'll talk about what could be done. But what do these two kind of cases mean in terms of this policy of putting girls at risk in Wisconsin schools?
Yeah, so these two cases are from the Seventh Circuit. So that's the Federal Court of Appeals that covers Wisconsin, Illinois, and Indiana. And the first of them is called Whitaker. It's from 2017. And it's a case where the court held that Title IX and the Constitution require schools to allow transgender students to use whatever bathroom they identify with. Now, I think this is a very bad decision, very wrong on the law. And so do a lot of others, including other courts who have disagreed with the Seventh Circuit's analysis. But schools in those three states have now been dealing with that case for going on 8 years. But obviously, it's a hugely important issue for the safety and privacy of girls in the school. And so lots of school districts have had a policy of sex-separated bathrooms anyway, and have tried to distinguish Whitaker or argue that it was wrong or come up with new arguments that the school districts in that case didn't come up with. So there's currently 3 of these cases pending in the circuit. One is back at the Seventh Circuit against the Mukwonago School District. And in that case, the Seventh Circuit directed all the parties to brief whether it should overrule Whitaker. And so we have filed an amicus brief urging it to do so, arguing that Whitaker was wrong, and sort of highlighting the effects on girls and what this does to safety and privacy in schools. A bunch of other parties have submitted amicus briefs as well.
We have the Trump administration's executive order on this. Is an executive order now just being treated like it's just like a suggestion? Executive orders, this is an executive order where he reaffirmed the meaning of Title IX as it was intended when it was passed originally, not to include gender identity, but to be sex specific. So is everyone just ignoring this, or do you have an anticipation that this is just a matter of like dotting I's and crossing T's and just officially getting a court to reject this crazy stuff?
Yeah, well, so the Trump administration certainly can and should interpret Title IX and apply its interpretation of Title IX, and I agree with its interpretation. But the Seventh Circuit had interpreted its view of how Title IX applies, and it's the binding ruling, at least for now, until it gets overruled either by the Seventh Circuit or the Supreme Court. So we need the Seventh Circuit to overrule these decisions or the Supreme Court to overrule these decisions. And I think that's going to happen. It just has taken a long time. Sort of just to illustrate how bad the analysis is, Title IX regulations say explicitly that schools can separate bathrooms based on sex. I don't know how you get more clear than that. So how the Seventh Circuit got to the decision that Title IX prohibits what it explicitly permits, it's not very good analysis, to say the least.
Yeah, so here's the problem. You got a bad panel. A different panel might have had a different outcome. I think that's the explanation for this. Just bad panel. People who just wanted to look past the explicit language in the law. Title IX does a whole bunch of different things. It also protects women or young girls from sexual harassment, sexual violence. I'm thinking of the Sun Prairie case. And the girls are in the locker room, and a boy comes in. He looks like a boy. He is a boy. He strips down and showers next to the girls. And they're where's Title IX for those girls? This is one of the things that's already happened in Wisconsin. Where is Title IX protection for those girls to be free from sexual harassment or the threat of sexual violence? Because it's not just about sports.
Right. That has long been the justification of having sex-separated bathrooms. And part of what was so bad about the analysis in Whitaker and the subsequent case is the court said, district, you're defending this to justify, as protecting safety and privacy, but no students have come into the case and said that they have concerns about this. So we don't really believe you that, anyone really cares if transgender students use the opposite sex facilities. And, we don't believe this idea that there's any risk that a male student will pretend to be transgender and get access to the girls' facilities. And so part of what we did in our amicus brief and have done in another one of these cases is to say, these are not just made up concerns. These are real. And in fact, we have this Sun Prairie example that you described where a male student claiming to be transgender went into the showers, stripped down completely naked in front of a bunch of freshman girls. And this is the kind of thing that can happen over and over again because of Whitaker's flawed ruling. And so we're very hopeful the Seventh Circuit's going to overrule that case. It seems like it's going to, but we're still waiting to see what their decision will be.
So how are schools in Wisconsin to proceed then? I know that there's a Moms for Liberty case. And so if you're a Moms for Liberty member, you have a bunch of protections that maybe some other people don't have, your kids or your direct relatives do. But how do schools proceed? Let's say I'm a school board person. I'm like, well, gosh, here's Trump's executive order, not just redeclaring the meaning of Title IX, but also protect girls in sports, protect girls' privacies. And yet there are these other two things. My corp counsel's telling me, yeah, but you know what? There are these two Seventh Circuit cases. What do you do if you're a school board? Do you go with the president or do you go with, people who actually said, talk about famous last words from those judges. Oh, nobody will ever just, walk into a girl's bathroom just cause, that should be like a cartoon balloon hanging over their heads. But how do you move forward? Does Jill Underly have a case when she says that, well, we're not going to oblige the executive order until, we see what's going to happen, with regard to the legality of it?
Yeah, it really puts school boards in a tough position because, again, Seventh Circuit's decision is binding on federal courts in Wisconsin. And so if they adopt a policy of sex-separated bathrooms and get sued, they are likely to lose the case until Whitaker and this other case called AC get overruled. But to their credit, a number of school districts have said, so be it. Even if we get sued, we are going to adopt this policy because we just think it's that important to protecting the safety and privacy of our students. And we're going to litigate it and we're going to take it all the way up if we have to, because we just think this decision is so wrong and it is so wrong. And so I'm pleased that the Quantico School District and the Elkhorn School District have been willing to litigate this. And hopefully we can get these cases overruled and school boards can go back to adopting sane policies.
Yeah. Now, if I remember, I'm not sure if it was one of the Seventh Circuit cases, but there have been a few federal court cases where school boards, or rather school districts, have made accommodations for students where they've said, okay, well, if you've got gender dysphoria, we have a special facility you can use. And is that in the Seventh Circuit case? Isn't that an option as a workaround solution in the event that, we got to wait on this?
You would think that it would be. And obviously, students who are dealing with gender dysphoria need a place to go to the bathroom. And I understand to an extent if they feel uncomfortable using the sex-designated bathrooms. And so what a lot of school districts have done is that we'll provide a sort of neutral alternative, a single stall bathroom that any student who's uncomfortable can use if they want. And the school district did that in the Whitaker case and did that in the other case. And the Seventh Circuit said, nope, that's not enough. You have to let them use whatever bathroom they identify with. And so, I just think the analysis in those cases was very bad.
Insane. Here's why it's insane.
Crazy.
Let's say I need to use a wheelchair and, there's only one door that's wheelchair accessible, but I say, and that's the door I have to use. Well, that's not good enough. You need to make all your doors wheelchair accessible. And I can't reach because I'm at a lower point, on the ground there. So you need to lower everything so that it accommodates me. That's not what the Americans with Disabilities Act would demand, right? You need to make accommodations for people who need accommodations. You don't need to change everything only for the accommodation of the person who's got a disability, who's got a condition, right?
Yeah, the original Whitaker case, part of what it highlighted, it said, well, the student has to walk the neutral alternative that was provided required the student to walk all the way across the building and made them late to classes and so on and so forth. And so after that, a number of districts, tried to provide more alternatives and emphasized factual differences about the layout of their building and said, look, we have 5 different neutral bathrooms, and over again, until recently, the Seventh Circuit has said, nope, none of those differences matter. Whitaker just held you have to do this, and you can't distinguish it based on the facts. And so again, it's just really put schools in a tough spot. But hopefully, we will get those decisions overruled soon.
Tell me why you think you're gonna get this at the Seventh Circuit when they've already twice said no.
Well, so the panel in the McGonigal case actually issued its decision earlier this summer and ruled against the school district and said, Whitaker and AC are binding law. We, the panel, think they were wrongly decided, but that's for the Supreme Court to reverse, and so we're just going to affirm. But then the Supreme Court issued its decision in Skirmetti this summer, and right after that happened, the panel vacated their decision and then said, we want all the parties to brief the effect of this decision that just came out, and we want you to also brief whether we should overrule these cases. So to me, that's a strong indication that the panel is thinking about and is likely to overrule.
Oh, good. You're getting the same panel. You're getting the same panel that said, we think these decisions were wrong, but they are what they are. We don't have the authority just to simply throw them out. And then they said, feel free to brief us. We're going to let this, and you're getting the same judges.
Right. Yep. It's the same panel that has already said they think the prior decision was wrong. And so we just think there's a good chance that they are going to overrule those cases, especially given that the analysis is just so bad.
Yeah, it's kind of bonkers if you think about it. If you think logically about it, it isn't logical. Well, once again, there's the Wisconsin Institute for Law and Liberty taking up the torch and fighting on behalf of young women and all women in Wisconsin, and certainly on behalf of parents. I do appreciate the time on the program. Luke Berg, and as we always like to say, go to will-law.org. And if you're of a mind to and feeling generous, donations are welcome.